Thank you very much. It's a great pleasure to be here. I'm speaking to you from Sheikh Jarrah in Al-Quds, a few minutes walk from St. Joseph's Hospital, where the attack on the pallbearers of Shirin Abu Akla's coffin took place. When Diana Bhutto was interviewed on the killing, she said that we have to remember that it was only possible because the Israeli soldiers were in Jenin in the first place. In this, of course, she was reminding the world about the illegitimacy of the occupation itself. She was seeking to counter an approach that would focus on particular horrific incidents only, without situating these incidents within the broader context of the occupation, and also understanding that as oppression and violence. I'm an international lawyer, and in my remarks today, I'll explain how international law does speak to the concern Diana Bhutto articulated, but this is commonly ignored. I argue that we have to think differently about the relevance of international law to the situation here. My remarks are based on a short policy brief, which I will post in the chat. Which is in turn based on a longer article in the Palestine Yearbook of International Law, which I will also post in the chat. And links to both are also in a pinned tweet on my profile at Ralph Wilde. Now, a common and mistaken view is that the question of when the occupation should end is a matter of politics only, not also international law. According to this view, ending the occupation can and will only happen when there's a peace agreement, because there's no international law rule requiring Israel to terminate the occupation, irrespective of whether a peace agreement providing for this has been adopted. So in the absence of an agreement, Israel is somehow entitled to maintain control. And during this period of continued occupation, the supposed utility of international law is only to serve as a basis for addressing particular alleged incidents or violations of individual and collective rights by Israel. Essentially, how ostensibly humane things are under conditions of occupation. And doing this using the rules of international humanitarian law, including occupation law, international human rights law, international criminal law, including the law relating to war crimes and crimes against humanity, and the prohibition of apartheid. And also to prohibit Israel from using its exercise of control to annex any part of the territory affected. Commentators don't tend to invoke international law to address the existence of the authority to occupy itself. This is an entirely mistaken view of international law. It ignores the international legal position that a state is only entitled to control territory that is not its own sovereign territory, and which is the territory of a population grouping who have the right of external self-determination on the basis of the self-defense component of the international law on the use of force. And as the test in the international law on the use of force is not met in this instance, the exercise of control, the existence of the occupation itself, not merely how it is conducted, is illegal. So the existential legitimacy of the Israeli occupation of the West Bank, including East Jerusalem and Gaza, is then a matter of international law, specifically the law of self-determination and the international law on the use of force. Now, the international law of self-determination concerns the right of a people to decide their international status, for example, to constitute themselves as a state, and to be self-governing on this basis, free from the control of another state or states. And the Palestinian people are universally accepted to have this right in international law. The anti-colonial form of external self-determination adopted in international law in the second half of the 20th century, applicable to the Palestinian people, was a repudiation of the concept of trusteeship over people. According to the trusteeship concept, people were ostensibly, potentially to be granted their freedom if and when they were deemed ready by colonial authorities. The post-war self-determination rule, which was the international legal basis for recognizing decolonization, scrapped this approach in favor of an automatic right. The new rule was rooted in the basic entitlement of people to freedom, not readiness. And the right operates regardless of whether the authority depriving the people of their ability to exercise self-rule agrees to relinquish control. Necessarily then, this form of freedom, the end of external control, is to be realized immediately. So in consequence, the Palestinian people are supposed to be immediately freed of the occupation. The occupation is supposed to end straight away because it has no valid legal basis to exist. Put differently, its very existence is illegal. However, a military occupation can be permitted if it's justified according to the international law on the use of force, specifically self-defense. If it's justified on this basis, it would not violate the law of self-determination and could be lawfully maintained. In consequence, the occupation would not be illegal and would not need to be immediately terminated. The Israeli occupation of the West Bank, including East Jerusalem and Gaza, as a military occupation is, to use the language of international law, a use of force, which is a euphemistic term for war, including military occupation. A use of force is only legally permitted in self-defense. And the use of force in self-defense is only legally permitted if there's an actual or imminent threat. And the use of force involved, here of course a full military occupation, is a necessary and proportionate response to that threat. The occupation here is manifestly outside the scope of what is legally permitted. In consequence, it is an unlawful use of force, an aggression. The very same violation of international law committed by Russia in Ukraine. And it is an egregious violation, given its 55+ year duration. What this means is that the very exercise of authority and control by Israel here is in and of itself illegitimate. It is illegal. Israel has no right to exercise authority here at all. So the way that Israel then exercises this authority, its treatment of the Palestinian people, covered by those other rules of international law I mentioned, such as international humanitarian law, the prohibition of apartheid, is in one important sense a secondary matter, because the authority is in and of itself illegal. So to address the question of whether and when the Israeli occupation of the West Bank, including East Jerusalem and Gaza, should end as a matter of international law, it's necessary to move beyond the typical exclusive focus on the laws of war, international humanitarian law, including the law of occupation, international criminal law, most of human rights law, the prohibition of apartheid, and the question of annexation. Instead, the focus needs to also be on the law of self-determination and the law on the use of force. So to conclude, all actors, states, officials of international organizations generally, the UN in particular, including the various international human rights mechanisms, other human rights mechanisms such as UN special procedures, mandates holders, the UN Human Rights Council, the Office of the High Commissioner for Human Rights, etc., and human rights NGOs and other interested parties who are concerned with the compatibility of the occupation with international law generally and international human rights law in particular, because self-determination is part of human rights law, need to move beyond addressing merely how humane, in inverted commas, the conduct of the occupation is, and making generalized affirmations of self-determination for the Palestinian people. They should affirm that the position that the continuance of the occupation is in and of itself a violation of the international law of self-determination and the international law on the use of force. On this basis, international law requires that the occupation end now. Every day that the occupation continues, regardless of how ostensibly humane its conduct, involves a violation of international law by Israel. Thank you.